Federal judge blocks Trump's order on workers' rights. In a significant turn of events, a federal judge has stepped in to protect the rights of federal employees, temporarily halting the Trump administration's controversial executive order that threatened to strip collective bargaining rights from hundreds of thousands of workers. On Friday, U.S. District Judge Paul Friedman ruled that a crucial aspect of President Trump's March 27 directive cannot be enforced across about 36 agencies and departments where employees are represented by the National Treasury Employees Union, NTU. This union, which advocates for nearly 160,000 federal workers, took legal action against the administration, arguing that the order would devastate their organization, leading to a loss of over half their revenue and two-thirds of their membership. Judge Friedman has promised to provide a detailed opinion in the coming days, but for now, his ruling offers a glimmer of hope for those fighting to maintain their rights. He has also set a deadline of May 2nd for attorneys to propose how the case should move forward. Union President Doreen Greenwald hailed the judge's decision as a triumph for federal employees and their rights, stating, "The preliminary injunction granted at NTU's request means the collective bargaining rights of federal employees will remain intact, and the administration's unlawful agenda to silence the voices of federal employees and dismantle unions is blocked." Interestingly, some agencies, like the FBI, are exempt from laws that require federal agencies to negotiate with labor organizations on employment matters. This exemption can be applied to agencies primarily focused on intelligence, counterintelligence, or national security. However, the NTU points out that no previous president has attempted to use this national security exemption to exclude an entire cabinet-level agency from these legal requirements. They argue that Trump's order seems aimed at facilitating mass firings and retaliating against unions that oppose his policies. Union attorneys have expressed that the president's use of this narrow exemption contradicts Congress's intent. Meanwhile, government lawyers contend that the union's request for a court order would interfere with the president's responsibility to ensure that federal workers are ready to protect national security. They emphasize the importance of accountability for agencies focused on national security. The IRS, the largest bargaining unit represented by the NTU, is particularly affected. Just a day after Trump signed his order, the administration initiated legal action against a union chapter in Kentucky, seeking to terminate the collective bargaining agreement for the IRS. The union argues that the administration has effectively admitted that its members do not engage in national security work. The impact of the executive order is significant, with the union projecting a loss of around $25 million in dues revenue over the next year. Some agencies have already ceased deducting union dues from employees' paychecks, raising concerns about the union's ability to function effectively. Union lawyers have warned that without preliminary injunctive relief, the NTU may struggle to exist in a way that meaningfully supports the federal workers it represents. In response, government attorneys have pointed out that courts typically defer to the president's judgment on national security issues, arguing that executive actions that are legally valid should be presumed regular. As this legal battle unfolds, the stakes are high for federal employees and their rights to collective bargain.